RCDVS Implementation and Related Measures Number 2 Bill. I want to begin by acknowledging the traditional custodians of the land on which we are meeting today and pay my respects to their elders past, present and emerging. The committee will be conducting today's hearing here in Canberra at Parliament House, and I'm joined by the Deputy Chair, Senator Collins, as well as other members of the committee. These are public proceedings and that are being streamed online via the Parliament House's website, and Hansard transcript will also be made. I want to remind all witnesses that in giving evidence to today's committee, you are protected by parliamentary privilege. It is unlawful also for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. I remind senators of their obligations under the Behaviour Code for all Australian parliamentarians to treat all witnesses with dignity, courtesy, fairness and respect. And I remind committee members and witnesses who are appearing via video conference and who are not speaking to ensure your microphones are on mute. On that note, I'd like to now welcome the Honourable Peter Tinley AM, National President of RSL Australia. Good afternoon, Peter. I understand that information on parliamentary privilege and the protection of witnesses given evidence to Senate committees and has been provided to you. Could I ask, for the Hansard record, could you please state your full name and the capacity in which you appear today?
So I'm Peter Charles Tinley. I am the National President of RSL Australia.
Now, Peter, did you have an opening statement or a short opening statement that you'd like to make today? Otherwise, we can go straight to questions.
I think that would be helpful, Senator. My opening statement.
If you have one. Yes.
Thank you. Questions. You have our submission, and as stated in that submission, RSL Australia largely Bills 1 and 3, which we believe, on balance, are in the spirit of the recommendations of the Royal Commission.
Peter,
I say largely
Peter, sorry,
because
mate.
the veteran community, including serving members and those transitioning to civilian life, have made it clear that, yes?
Sorry, you've just broken up. I think we've got a bad internet line. Can you just start again? And maybe if I could suggest, if you may turn off your camera, could you just turn off your camera and then leave your microphone on? That might help with the bandwidth.
Yep.
Far away.
Okay, I'll start again if that's right. Thank you for inviting me to appear today to represent RSL Australia, and I look forward to answering your questions. As stated in our submission, RSL Australia largely supports the bill. That includes Schedules 1 and 3, which we believe, on balance, are in the spirit of the recommendations of the Royal Commission. I say largely supports because the veteran community, including serving members and those transitioning to civilian life, have made it clear that the provisions in Schedule 1 and 3 must meet three key principles. They must afford the same rights to privacy for veterans and their families as can be expected by every member of the civilian community. Likewise, personal information, including health records, should not be transferred between agencies without informed consent and the right to dispute, notable and add information to their own records. Add information to their own records. Finally, the veteran community understands how solid evidence-based research can contribute to policies and programs that will deliver direct outcomes to them, their families and their comrades. Making de-identified administrative data and especially cross-agency data more widely available to the research community is strongly supported, and the bill could extend access to that data beyond government and government commission research. RSL Australia asks that members of the committee consider and apply those principles when examining the provisions of the bill, in writing your report and making your recommendations. And that there is our opening statement, and I'm more than happy to answer questions.
Thank you very much, and I take it you're happy to provide us with an electronic copy so we can just get that circulated to committee. Thank you. Now, I'll just kick off. I've got just a couple of questions that I'll hand over to the Deputy Chair. Peter, your submission, as in RSL Australia's submission, expresses support for information sharing subject to a right to review and correct records before they are used by DVA. I was hoping you could answer this for myself, please. Could you please provide an explanation in terms of how RSL Australia would like this to function in practice?
Yes, it's easier in the statement than it is in the practice. I get that, I understand, but I think the principle needs to be observed and understood. That is, corrupted information, if you like, or incomplete information, let's be more plain, is actually more harm than good. And if the individual doesn't have that capacity to actually verify that information or add or subtract from it or make claim to add or subtract to it, then I don't think it's going to have helpful outcomes.
You also call for consent, privacy and data protections. How should Defence and DVA implement these protections without undermining, I guess, the bill's intent to facilitate early and simple transfer of records to reduce any administrative burden through that transition period?
I think this is a continuum of activity. So we're in the point of transfer, decision to transfer, and the reception of the transferred data. Does the individual's rights get observed? Now, I'm relaxed, and RSL Australia is relaxed about where that happens prior to transfer or post transfer, as long as there is a point in time where the individual can have access to the data that's been transferred and understand the full intent and exact nature of it.
The bill also makes separation automatic for any member imprisoned for an act of serious violence or a sexual offence and bars their return from service. Speaking for the community that you represent, do you think that the provision strikes the right balance?
I think in these cases we do have to contemplate the no harm component here. Do no harm is an easy thing to state, but I think we have to consider all those in the orbit, if you like, or in the constellation around a particular individual, and make sure that we are weighing up the relative benefits of exclusion from particular processes and or privacy arrangements.
Do you support the strict requirements for ADF service?
Yes, I do.
Okay. Deputy Chair, happy to hand over to you.
Thank you, Chair. Welcome, Mr Tinley, and thank you for your time this afternoon. Just a question on historical misuse. You cited that historic misuse of DVA data where identifiable records were used for research without consent as a reason for caution. I'm just wondering how your proposed governance would specifically restore that lost trust?
I think that's a very, very good question. It's a very difficult one because when we had those data breaches through a couple of universities, well-intentioned, and I make no accusation whatsoever, but at that breach at that time, we call it that, there was all these protocols in place. But the reality is people got lax, and I don't think any law, principle or process is going to stop for human failure in this context. So it's a bit of a difficult position here. You want the outcomes of the research, you want the outcomes of the use of the data, but we really have to find a better way where continuous education, monitoring, and provisions around who can actually have access to the data. I hope, and I want to refer to the work of Dr. Sandy McFarlane, who's been advising right through our Middle East area of operations study, scoping study, and many others, highly regarded in this area, has a root and branch understanding of how these breaches occurred and how we need to have a better sense or better approach to a whole of record management and monitoring.
Mm. Well, on that,
hopefully the committee's actually reached out to him. If he hasn't, I would highly recommend it.
Okay. On that issue of who has access to data, you also suggested that de-identified data could be shared more widely with universities. So just in terms of that, what safeguards should be in place before you support extending beyond direct government contractors?
I think it's fundamentally important. It's not just those that are working in the discrete veterans health space. I think there are a range of fundamental whole of community research studies going on that this would make a great contribution to, or this sort of de-identified data set. What we don't have is a unified group around command and control. I use that term, an old army term, an old military term, which is there is no centralised committee where DVA has its experts, where Defence has its experts, and where the relevant other agencies are actually concentrated to actually make genuine choices, the gatekeepers, if you like. And that's what we need here, I believe, is one that curates the data, make sure it is appropriate for distribution, and that the receiver is completely trained and prepared to receive the data.
In your submission, you expressed concern about personal information or financial data being inappropriately disclosed to former partners, which could affect family court proceedings. So do you think that the bill lacks a sufficiently narrow definition of what constitutes information about their own entitlements? Do you think that the bill should explicitly list what constitutes own entitlements so that the disclosure is strictly limited to what the former partner is eligible for?
I think it's really important that we get the balance right between protections of people and their safety, and I would characterise that as being a higher priority than the individual rights of somebody over their data. That's my default position, or mine, the League's default position. That's easier, again, said than actually put into practice, because there are many intervening or sort of intersecting issues here. But we really need to make sure that when we do implement this bill, that we actually have the processes in place to understand where those ones that aren't the unintended consequences surface. We must be able to have a rapid response to that.
Okay. Just on the defence support workers definition, you described it, or you considered it to be too broad. So, why is it too broad? And what types of workers do you believe should be excluded from having the power to disclose sensitive information?
Well, it's not so much the workers. I think it's the institutions that control those people that have contact with members and or any individual. So making sure that the organisation is fit for purpose and that the people that are working inside that organisation are sufficiently trained and understand the protections they have to put in place. Now, we've got very developed in many areas of our human services provision across the Commonwealth and in the states, processes for people to be trained and procedures for them to follow. I think that's more a comment around the safeguards of the organisation delivering the service than the actual individual service service delivery.
Okay. Just on breach transparency, you called for a clear complaint process for data breaches to be established alongside this bill. So do you think that the current legislative framework provides veterans with enough transparency to know if their privacy has been compromised?
I think that's requires eternal vigilance. We see in every other agency where we have had data breaches and etc. We do need to limit access and make sure that limitations are appropriate for the outcomes that we want. So this is a circumstance where we know. I think we have to have the basis of the assumption there's going to be a breach. It's how we respond to the breach that matters, and making sure that we understand the unintended consequences that are created as a result of this bill, and that we have greater control and limit access to the absolute necessary required.
Okay.
All right. Thank you, Mr. Tinley. That's all we have for you today. I want to thank you for your time and the submission that you and your team have put together for the committee. And if there was any responses to questions on notice, we just simply ask to provide that by Thursday, the 27th of August by 5 p.m. Thank you, appearing for today's witness. Now, I'd like to...
Oh, you're going. Sorry.
Sorry, Pete, do you have something else to add?
No, I was just going to say, I think I owe you the opening statement if you didn't have it already.
That's okay. I'm sure the Secretariat will chase you up for it, but if you email it across, that'd be great.
Excellent. Okay.
Okay. I'd like to now welcome Dr. Mark Laxer, OAM CSM, Chair of Legacy Australia Incorporated. Good afternoon, Mark. I understand that information on parliamentary privilege and the protection of witnesses given evidence to Senate committees has been provided to you. Could I ask for the Hansard record, if you could please state your full name and the capacity in which you appear today, please?
I'm Dr. Mark Roger Lax, Legatee and Chair of Legacy Australia Inc. and I appear before you in that capacity.
Thank you.
Thank you.
Now, did you have a short opening statement for the committee
I provided
today?
a short opening statement
Fantastic.
to the Secretariat. I'd just like to highlight a couple of very short issues on that, just for the record, if I may.
Yes, please, go for it.
As you're well aware, but just for the record, the Legacy organisation is a veterans organisation that is exclusively dedicated to supporting the families of deceased veterans and those that have given their health Australia-wide. We have 42 clubs across the country and one in London, and I can explain that if you need me to. Today we support over 25,000 beneficiaries, family members, with 3,100 legatees who are all volunteers. Our role is to ensure that no family member of a deceased veteran or veteran who has given their health suffers social or financial disadvantage. We provide peer-to-peer support for whole of life to the families of veterans who have died or given their health, and it's for the whole of their life or the whole of our life, because we swear that we'll do that. This provides continuity of care to support the needs for social engagement, education, advocacy for entitlements, and where necessary, financial support, particularly for children. Thank you, Mr. Chair. I'm happy to take questions.
Thank you, Doctor. Now, I'll just have a couple of questions, then hand over to the Deputy Chair. Sure. Legacy Australia's submission states that the focus on serious, violent and sexual offences sets the bar for exclusion from service too high. Did I read that correctly?
Sorry, I have hearing aids, so I'm a bit deaf. But regarding the sexual, it's a part of Schedule 3. We would suggest that the limitation for employment of people joining the ADF, where it says they have to have been convicted and have served a prison sentence, may be too tight. And I'll explain why. Because once a person's been convicted, they have a criminal record. In the past, certainly in my experience, and I did 50 years of service in the ADF, if you had a criminal record, you would not be eligible for enlistment in the ADF. There may be some extreme circumstances where that has happened. So consequently, what we have found in Legacy, and I've just looked at our stats, and we've just updated these, and we've only started collecting them, but partners of veterans who have experienced family and domestic violence, including sexual violence, we have 249 at the moment, but we're expecting that to continue to increase, unfortunately. So our view is if we let these people into the ADF, perpetration can continue, and of course that leads to family issues, and of course once they're discharged, those issues continue. And in the case of the Wellbeing Agency, this is one of the things that I know they will be looking at, and we intend to partner with the Family Wellbeing Agency as well.
Thank you for that response. I guess my follow-up question was, what sorts of harmful, unacceptable behaviour does this focus exclude?
It's a shame in our society, domestic violence, we all know that. It's been hidden for too long, so our statistics going back years don't really let us know that we know that it has been a problem. Legacy's role is to support the family member and particularly the children when this situation occurs, and we refer those families to specialist advice, those people that are professional, either social workers or health support workers. So legatees are really just there to help the family transition through to what could be a really terrible circumstance.
Are there any changes that you'd recommend to the committee in order to address that particular issue?
Well, Legacy would like to see the removal of the and imprisonment to that requirement. If a person's been convicted, they've been convicted. And in our experience, once you've been convicted of that sort of behaviour and you're let out, it's not likely to stop. So our concern is really in that regards.
And in terms of a veterans and families perspective, does the definition of family in the bill that's been drafted, and I know there's been a lot of discussion about that. I appreciate you've got a copy.
Acts Interpretation Act.
Yeah, you've come prepared.
We have actually had this discussion quite a few times. I've appeared before you about 6 times this year.
Yes, I'm aware, don't worry.
So I'm familiar with you.
I know. Yeah. But in terms of this bill, for the 6th time, does the definition of family in this bill capture, I guess, the people that you'd actually like to see needing support?
Yeah. In terms of the bill, it probably does. In terms of our support for family, we support those who say they are a family. So if they're a family member that might not be just the partner and the children, it may be stepchildren, it may be beyond the nuclear family of old. So we don't discriminate in that regards, and if someone comes to us and says, I and my family need help, we give them help.
I do note the Royal Commission made a number of recommendations about defence families, particularly on with respect to how we can better support families. My question to you then is, how will this bill support better communication with defence families? So I appreciate there's all the focus on support, but in terms of communication, I think that's the other piece in the puzzle.
The Veteran Family Commission is a huge step forward. Commissioner Wilson, we have regular communication with her. In fact, she attended our advocacy forum this month and presented her position and is more than willing to engage with us. Just on the Wellbeing Agency, I know Mr Brendan Cox has just begun his role in that position, so we will engage with him directly once he's had a chance to get used to the job. But one of the things we would like to think about is, in reference to this legislation, is while the the Wellbeing Agency supports a veteran for a 2-year transition, through their transition out of the defence system into their civilian life, it only says it supports the families for 12 months. Well, we think that should be 2 years also. And especially in the case where the veteran has given their health, whether mental or physical, and is incapable of helping their family get through normal life, we will help the family as well. So for us, if we have a partnership with the Wellbeing Agency, it makes sense to me that goes for the life of that actual contract between the veteran, the family member and ourselves. So that's what we'd like to see, that the 12 months gets extended to the 2-year period.
Thank you, Dr Lux. Now I'll hand over to Deputy Chair, Senator Collins.
Thank you, Chair, and thank you, Dr Lux. Just on advocacy pathways,
yes.
You noted that Section 70MA only names the executor or family member as permitted recipients of health information.
Yes.
So how does the lack of a formal pathway for authorised advocates like Legacy to receive this information directly or even with family consent impact your ability to assist grieving families with timely compensation claims?
It gives us a huge time gap between the passing of the veteran and presumably it's a passing situation, it might be given their health, but in passing of the veteran and us being able to support the spouse and the children get their just entitlements. And it's not just DVA entitlements, it's ComSuper, possibly Centrelink. Now, I read the Privacy Act, and at 1988, I think it is, once you die, privacy to you ceases. I may be wrong, but it seems to me that if a veteran is deceased, why is it so difficult for an advocate who's authorised by the family as their representative to get access to those records unless it goes via a circuitous path through to the family? So I just think that we need to be able to ensure that fully authorised and accredited advocates, and the Institute of Veterans Advocates is now up and running, which authorises advocates and makes sure they have the correct training and confidentiality clauses. It seems to me that if they have access to the health records earlier, if it's a health matter, which it usually is, it'll expedite the system.
And it gets difficult, doesn't it, when you've got veterans that are in special forces doing classified missions and they can't actually disclose where they were or what they did.
I accept that, and having spent a lot of time in the Air Force, I know what it's like. But generally speaking, the health records don't normally go through where they're operating, what they're doing. It's more like what injuries they've suffered, what mental health challenges they're facing and so forth. So I wouldn't say that it's not possible to pass the whole record, but it's certainly the majority of the records which we would use as advocates requires that health information of what damage has been done to the member, rather than where they served, what operation they were on, how long they were there, because as you know, the way that an advocate works is they also have to apply to the statements of principles, which relates to the equality of the claim that they will receive. Yeah. So I don't know, there's a roundabout saying that some information could be withheld, but it still wouldn't stop us from putting the claim in if we got the bulk of the health matter put forward, health material. And by the way, advocates, all the ones that in legacy are sworn to confidentiality. So once say a family member comes to us to seek support and putting their claims through, we sign an agreement with them to say that we will hold their information, personal information, confidential, and any material we have is returned to the family once the claim goes in. So we don't store tons of health records of members.
Just on duration of support, you support benefits for former partners, but you argued that 12 months is insufficient, and I think that's a pretty good argument that you put forward. So if you can just go into that a little bit more,
yeah,
why
sure.
you recommend extending the support for 2 years and how this would align with the Veterans and Families Wellbeing Agency's mandate to better assist families in stabilising.
Our experience is that when a family is experiencing loss through either death of the veteran or through them taking their own life, which is very sad, it takes a long time to get the paperwork together, death certificates, medical records, advocacy paperwork. And so we tend to let the family just have a little settle period after I presume, a funeral, because they're suffering immense grief, as you can imagine. So we won't engage until a reasonable time after, and we actually let them know that they can come to us when they're ready. There's a time period there. Then, once we get authority to act on their behalf as an advocate, we would seek the right documentation from ComSuper, from DVA, maybe from Centrelink if there's an issue there, and that applies to their children and the members of their family that they declare as a family. So again, that takes time, and also, often as not, if they're living on a military base, they will be evicted at some stage, and they will have to find a new home, they'll have to get the kids into new school, and all that, again, takes their priority. So this can actually take 9 months, 12 months to get themselves settled and sorted before they even start thinking about it. The one thing which we will do soonest is put in for the funeral benefits, if that's applicable, which helps them with that financial burden of a funeral. And as you know, the funerals are very expensive. So that's why we would argue that in fairness and for equitable reasons, the extension to 2 years would give us time, it would give the family time, and it would align with the work that the Wellbeing Agency will be doing. So I think that's probably fair and reasonable.
Thank you. And just on the coercive control matter, unacceptable, you did argue that unacceptable behaviour standards should be defined broadly enough to capture coercive control. Yeah. So what risks are created if the bill focuses only on serious offences but ignoring coercive control, isolation, financial control and surveillance?
The bill does focus on higher level offences, including sexual violence, but we would argue that coercive control is very close to that. How would I'm not a lawyer, so I can't define it for you, but certainly we've seen instances where families have had to separate from the partner, physically separate because of problems with the interfamily relationship, and that also goes towards reversionary benefits for pensions, and I've spoken of that in the past, where often as not ComSuper may not necessarily pay reversionary benefits when the member dies separated from their family, but that's another story. Mm-hmm. So we're across all those issues, and certainly we would like to see that that clause at least included, if it would be possible. Okay. And how you define it would be up to, I guess, the government or the relative authorities.
Okay.
Yeah.
I have 3 more questions if you wanted to share the call.
No, you've got the call.
Okay, thank you. Just on rank as a coercive lever.
Rank, yes.
Yes.
Yep.
You identify rank as a coercive lever and as a structural risk factor in defence. So how do you think the bill should, or its supporting guidelines, address rank-based coercion?
I think this is, well, first start, the higher command system needs to know that it's happening, and that's a real problem because it's often in the house, and if there's a couple that are both serving, one or even in the same unit, and it's often, well, I won't say often, but it may be the CO or the senior officer that's perpetrating the rank coercion. It needs to be taken to the highest level. So the thing is with reporting, there is a reporting mechanism within Defence. I'm aware of that. I don't know what it says now because I've been out for a couple of years from the reserve. So, yeah, it's a tough one, but it's certainly one that needs to be highlighted, and particularly to the Defence higher management. I'm pretty sure they're aware of it, actually.
It is complex. Do you think there's a way that you can treat it as a risk factor requiring scrutiny rather than just a policy breach?
Well, I think it's a training issue as much as a behavioural thing. I think that certainly that education and continual, every year the Defence Department goes through a day of training for acceptable behaviour and unacceptable behaviour, as you know. This is part of the unacceptable behaviour training that they would receive. How it's applied within the Department of Defence, I'm not able to answer.
So just on the point that improved data sharing could potentially expose victim survivors to retaliation. So what specific legislative language do you think, or safeguards, let's say, would you like to see in this just to, to ensure that coercive control, disclosing violence, doesn't result in professional advantage?
Mr. Tinley mentioned on his presentation that it seems to me that there's got to be a fairly tight mechanism to manage the data, who it's released to, how it's released, how it's used, and how it's stored. One of the issues of these data leaks is the storage systems. And so how we actually put that into legislation without being overly prescriptive, I'm not sure I could tell you how to do that. But certainly we would like to see some data, de-identified data, be available to the research agencies, because there's a whole lot of research we as a country need to do about what's the future of families and how they cope with some of these issues that are emerging. So, yeah.
Okay. Final question from me. Mm-hmm. Why do you think it's critical for the Defence and Veterans Service Commissioner to have visibility of zero tolerance conduct standards rather than focusing on administrative and procedural matters?
The way I understand her appointment, I've spoken with Ms Mackay, it's to ensure that the recommendations of the Royal Commission are enacted and put into place rather than just shelved. And so I would think that as a commissioner, she should have the power to be able to investigate across the issues that she's been charged to manage and look after and report on too. I believe she has to report to this Parliament annually. So it would seem to me there's 122 recommendations. The government, I think, have endorsed 107 with a couple of agreed in principle. But a lot of the things we've discussed today are right in the purview of what she has to manage and consider and report on. And one of the things I'd like to think that she would do is report when they haven't been implemented, which might be a bit tougher than reporting when they have been.
Okay. Thank you, Dr. Lax. Thank you, Chair.
Thank you.
You're most welcome. Doctor, on that note, thank you very much for your brief attendance, but very important attendance, and thanks for your submission as well too. I really do appreciate that.
Thank you, Chair. My pleasure, and thank you for the opportunity to appear before you.
Excellent. Now, on that note, and if there was anything that we had asked for you to take on notice, I think the 27th of August, 5 p.m. is the deadline. I'd like to now welcome our next witness, who I understand is online, Shannon Hennessy, Chief Executive Officer of Veterans Emergency Services and Police Industry Institute of Australia. Just checking to see.
Yes, I'm here, Chair, thank you.
Hello.
Sorry, my camera just seems to be starting up.
That's okay. I'm sure there's another term for it, which I won't repeat, but I'm sure we all have gone through that process. Now, I understand the information on parliamentary privilege and the protection of witnesses in given evidence to Senate committees has been provided to you. For the Hansard record, could I ask that you state your full name and the capacity in which you appear today? And if you are having issues with the video, it's okay just to turn off the video as well.
No worries. I think that's sorted itself out now, so hopefully you've got me there. For the record, my name is Shannon Hennessy and I'm the CEO of Vespia Limited, and I'm representing the Institute today.
Now, Shannon, did you have an opening statement or a brief one you'd like to provide the committee with today?
Yes, I'll just provide a quick overview of Vespia and what we do, just for context for the committee. Vespia is the Veterans Emergency Services and Police Industry Institute Australia. We represent organisational and individual members across the country who are working to support veteran, first responder and families. And we do that through providing professional development opportunities, advocacy in these sorts of forums, events such as conference and recognition through awards. Brief synopsis of what we do there, and that will conclude my opening statement.
Excellent. Short and sharp. I like that. Now, Senator Cox, you have the call.
Thank you very much. And thank you, Ms Hennessy, for joining us this afternoon. Your submission calls for flexibility in Schedule 3, which is about safe separation payments. Can you walk the committee through what some of your concerns are with the 12-month period?
Absolutely. So we spoke sort of briefly in our submission. I think our concern, and this has been something we have raised in previous submissions around these sorts of wordings, is that these sorts of scenarios playing out with families, especially where domestic violence may be a factor, is that then very rarely resolved on any kind of timeline. So I guess the thought process that there's 12 months of a payment and then that's that is a bit restrictive. In I was just listening to the gentleman before, similar sort of scenario that there may be lag times, there's issues that crop up in trying to find housing, and especially if that then is going to court cases and things like that, it's not going to be resolved within 12 months. And the last thing we would want is for a defence family to be put in further harm's way by being in financial issues, like experiencing financial issues there as well. So having the flexibility, especially on the minister's behalf, to say, yes, we can see that this is an ongoing issue and that we need to continue to support this family and do what we can there, is paramount to their safety overall, instead of saying the 12-month deadline has been met and that's that and you're on your own. I think there's sort of a duty of care in those sorts of scenarios that warrant additional scrutiny.
Great. You've sort of gone into the second part of that question, but are there any specific changes that you would recommend to address this part of the, particularly the 12-month period that you've raised, but are there any specific changes that you would recommend to the committee?
I think our recommendation in there really just speaks to giving those powers to extend those safe separation payments where necessary. So obviously if someone is set up and good to go and everything's okay, of course that 12-month applies, but allowing or having a mechanism that allows review and for the minister or a commissioner to make a decision to continue payments where it is warranted would be our recommendation.
Excellent, thank you. And just my second question and last question, Chair. Can you explain to the committee what you believe will be the important safeguards that need to be in place for information sharing between Defence and DBA?
As far as safeguards are concerned, look, I know that this is going to be a complex thing to try and do. I don't think that anyone would shy away from the fact that information sharing between departments is not an easy undertaking regardless. I think safeguards, especially where there are instances of misconduct or sexual violence or anything like that, that de-identification to public reporting for us is really important. We've also spoken in our submission there about who can make decisions, and the delegation of authority, in a sense, just ensuring that the people that are making decisions around what data is shared, that they are trained and supported in doing that, not just saying, you can make the decision now, off you go. That we are making sure that anyone who is in those rooms and making those decisions is informed and is trained to do so. I think on a technological level, of course, just ensuring your cyber safety and all those sorts of things are sort of non-starters and no-brainers, really. But we are certainly very much in support of the sharing of data. It's something we've sort of come up. I've been in the sector myself about 10 years. And wouldn't it be great if the departments just talk to each other? Has been a sort of ongoing discussion we've had that whole time. So certainly in support, but governments have their procurement processes and just making sure that your cyber needs are met and that anyone accessing that data is trained.
Excellent. Thank you very much. Thank you, Chair.
No worries. Deputy Chair, Senator Collins, you have the call.
Thank you, Chair. Thank you very much, Ms Hennessy. First question on Schedule 5 and transparency on the DVSC. I'm just wondering about discretionary tabling, and you have noted your concern about the change from mandatory to discretionary tabling for the own motion inquiry report. So do you think that automatic transparency is particularly important, especially in the first few years?
Absolutely. I think where transparency is, you raised that should we be transparent? Of course. It's something that we as an institute pride ourselves on, that every decision that we can or need to be transparent about, we are as much as we can. And it's not to say that every minute detail needs to be made public, but transparency is the key to building trust. I think something we've seen over the last 12 months with a lot of this legislative action, that it's great that we're making strides in these areas, but underlying and even in our own consultation, we've noted that trust has just simply been eroded. So the more that we opt to forego transparency or even have an option that we could not be in any sense, that shouldn't be the path we take. So of course, in the first few years, and how do we continue to grow and learn and build off the work that we've been doing? Well, that's through transparency and reporting.
Yeah, so just on that public confidence issue, DVSC was established because public confidence and Defence's internal accountability had been tested. So just to be clear, you think moving to a discretionary table model risks undermining the independence of the Royal Commission that was intended for this body?
Absolutely, we would agree that the ability to, in a sense, hide data or hide information, especially in these first few years, the Royal Commission itself was such a massive push to even undertake this inquiry, and even just to put forth what we already knew what was happening in the sector, and we knew the sentiment, we knew what was going on. But to have such an in-depth report that we are now all as a sector accountable to, having any mechanism that would undermine the transparency of reporting would itself be a failure to the community. That even if data wasn't hidden or it was just it didn't make sense to report it, the fact that that mechanism is there leaves questions unanswered and allows that sort of almost negative curiosity to breed. That community building and trust building is so important if in this phase that we're in, that people have put so much on the line to tell their story and to improve things and to make change. So we certainly have almost that duty of care to be as transparent as we can across the board.
So you've made the point in your submission that if the government continues with the discretionary element, that you said you recommended that the Commissioner's annual report must at least record how many inquiries were finalised and whether they were tabled. So how do you think that this minimum requirement ensures the practical effect of this change remains visible to Parliament?
Look, I think, it just sort of goes back, in my opinion, to having eyes on what's happening. If you're at a parliamentary level, you guys aren't privy to what your reports are coming through and what's being tabled and what the data is saying, then how do we continue to have discussions around legislative change if things are sort of being withheld? Even if that your report says nothing happened, that's an important piece of work. And I think especially from a community standpoint, even to have a report that says nothing bad happened, nothing changed, this, that, the other, it's all very boring. That's a great sign for us to show that maybe things are working because we're not having reports come through, or that we're seeing this uptick of more positive data in that there is no data. I think that's still important. So you having that be a sort of, I guess, a mandatory part that those reports are tabled, it also sets an expectation for us all that we know what to expect from the Commissioner when things are going to be coming through. We're not sitting waiting going, has anything happened? Just removing that ambiguity is going to be very important. I hope that answered that one.
Yeah, no, that's good. Thank you. Just on Schedule 1 and 2 and the oversight of data and health governance, you recommend a periodic independent review of ministerial guidelines and legislative instruments that will govern the new data sharing framework. So why do you think the initial consultation with the Information Commissioner is insufficient to ensure the scale and durability of oversight once a framework is operational?
Well, I think with anything, it's unrealistic to expect that an initial inquiry will answer all questions and you not allow for improvements over time, especially introducing something as large scale and as new as information sharing between departments. There has to be a growth mechanism there. We need to be able to see what is going wrong, what's going well, and to be able to make sure that we're improving every step of the way. That an initial inquiry, especially for such a large-scale project, can't be everything included. And having that independence in review for us is quite important as well, that you can't mark your own homework. With the work that we do, we're very big on that it's that independence is necessary to make sure that all of the good and the bad is raised to the top, and that is dealt with accordingly. So we would always argue for independent review where feasible, and just allowing that understanding that it may not go perfectly the first time, but growth is a good thing. Change and upscale is difficult, but we always have a chance to learn more and to do better each time, and technology is going to continue to evolve and change, and we need to be on top of that as well.
Thank you. You also recommended plain English summaries. So in your view, what are the risks to ADF members and veterans if they can't understand how their personal information is being shared across agencies?
Look, I think the most important thing to remember here is that we are dealing with potentially vulnerable communities. That when we're talking about people's personal data, this is something that we're talking about not just in defence, but as a Australia-wide issue about how we understand how our data is being used and shared. And this is a massive topic at the moment across as technologies evolve, especially with the introduction of things like artificial intelligence. So when we're dealing with communities that are potentially vulnerable and we're introducing something new like data sharing that can seem big and scary and unknown, it's essential that the people who are going to be affected by this, whose data is going to be shared, that they understand what's happening. No communications that come out of department or out of government, and I say this as a ex-parliamentary staffer myself, should be in legislative jargon. We as legislative professionals understand what some of these terms mean and how things are phrased and why they're phrased that way. When we're communicating to any public, it has to be in plain English and in terms that they understand and can accept, so that they are well informed to make decisions on their own behalf as well. Agreed.
On the extension of support, so you've you've recommended a mechanism for the Minister to extend the 12-month safe separation payment period in exceptional circumstances. So just on the specific legal or practical hurdles, like ongoing protection order proceedings, what have you observed that might not resolve within a rigid 1-year time frame?
Look, I can only sort of speak from anecdotal experience, you having worked in the space, that you, especially if there is an instance of domestic and family violence, I think it's unrealistic to expect that anything in that time happens on any kind of time frame, that we are then adding a pressure to the victim in this sense that, well, they've only got 12 months of payment to get their life sorted. And if there is court cases involved and if there's children involved, especially, things don't move at the pace that a department can mandate in a sense. And I think when we're, again, dealing with that vulnerability, we have that duty of care to ensure that they're taken care of, that we're not adding those additional pressures. And if a defence family is in this position at the result of the actions of a defence member, that extends even further, that we need to ensure that they're taken care of at every stage. So expecting that 12 months to the dot, you're good to go, off into the world you are, I think is unrealistic. So while I can't give you any specific circumstances where I've seen this happen, I do know that it has. It's certainly things that we've seen in consultations that we've done with both defence and first responder women who are actively serving. We know that some of these situations can be ongoing. So it's not even if they report that 6 months from now something's going to be fixed and resolved, this could be ongoing for years. So I think it's just having that option for the Minister to say, okay, we need an extra 6 months just to make sure that you're okay, that you're set up, that everything's good to go. Those mechanisms need to be included. Okay.
And just final question from me. Thanks, Mrs. Hennessy. Just on the delegation of decisions. Now, you've expressed your concern that decisions regarding a person's fitness to serve could be delegated to members as junior as a Chief Petty Officer or an APS Executive Level 1. And this can be a pretty career-defining decision, these determinations. So what specific training or escalation pathways do you think can act as a safeguard against inconsistent application of these powers?
As far as trainings go, I think there's a multitude. You obviously, things that are trauma-informed, but obviously legislatively informed. And I think understanding that if junior officers or junior staffers are making that decision, that they are aware of the severity of what they're doing. So internal trainings, we would be more than happy to take that sort of further on notice and investigate, and potentially do some consultation within our membership of professionals. So while we couldn't make that decision for defence and for the APS, we would like to see at least sort of, that potentially victim-led and your survivor-led trainings about what it is to have suffered at the hands of that level of perpetrator, and that the people making those decisions are just very well aware of what that means, not only in the moment to make the decision, but for the long-term reputation and longevity of defence, and what that person's career could then entail.
Thank you, Mrs. Hennessy. Thank you, Chair.
Thanks, Deputy. Now, Senator Shoebridge, you have some questions for our witness?
I do. Thanks so much to Legacy for all the work you do. And
we're not with Legacy, just so you know.
Oh, I thought we were.
No, we are Veterans Emergency Services
I had it
Police
pointed to the
Industry
wrong one.
Institute.
We are with the Institute?
Yes.
Oh, okay. Terrific. That slightly changes my questions, but that I'm still grateful for Legacy's work.
As a former Legacy staffer as well.
Well, indeed. I think we could probably join. One of the issues that's repeatedly raised in the submissions here is about data security and ensuring that the data that is shared, and I'll just say, from my perspective and the Greens' perspective, there are powerfully good reasons to ensure that data is shared so that veterans don't have to keep repeating trauma, repeating their their history, and there are powerfully good reasons to have data shared appropriately. But do you have any thoughts about whether the bill contains sufficient protections to ensure that privacy is protected, and also so that people who are serving, members of the Defence Force, feel free to actually go and get the help they need, knowing that the information they share with the medical practitioner and allied health won't find its way into the hands of their superiors, for example?
Absolutely. I think that last point is one that needs to be focused on. We know that that's been a barrier for active service members to seek help for a multitude of reasons, and not just mental health, but physical health as well. That in my experience, years ago, I had a girl that was discharged because she broke her ankle. And you're wishing she just hadn't mentioned that there were ongoing issues with that because she loved being in the Navy. And that sort of derailed her career when she was only 23. So, it's not just your help seeking as far as mental health is concerned, it's help seeking across the board, and even for your emotional supports and things like that. So I think it is paramount that we ensure that members feel safe, that confidential information remains confidential. I think from an external point of view, the data for us, and at least in my personal opinion, based on my experience, the data that we require as service providers, we don't need the minutiae. The numbers are enough, and that can help inform further research and further data collection. It can help inform how we build programs and design support networks and systems. So having the access to medical records and things like that shouldn't be in question. That should remain confidential. Whether this piece of legislation has enough safeguards, I think not that I'm not confident, but I think it's good to question. I think if we were like, yep, this is perfect, no changes, no notes, that would be unrealistic. As I mentioned before, I think the adaptation and the want and the ability to continue to grow and to perfect over time is important. That the consistency of independent review and to not only of the structures that get put in place, but of the legislation itself is important, so that we don't stop here. This isn't the last time we should ever talk about this. This needs to be an ongoing review. And again, that goes back to trust building as well, our ability and our want to continue to have these discussions, as difficult as they may be.
Many of the concerns that have been raised with my office have been around this issue of data security and privacy, and ensuring that, if information is shared, that it's not shared to the detriment of either veterans or of serving members in the Defence Force. Have you considered, and I'm more than happy for you to take it on notice, if there are any additional protections that maybe we should consider as a parliament to give a level of comfort to the community?
I actually would like to take that on notice, if I may. I think that would be an interesting piece of consultation for us to do, to go out to our member organisations and probe a little bit further. I think holistically, data privacy and security is an ongoing topic, as I mentioned before, Australia-wide, and we should always be questioning it, but we would be happy to do further consultation in that area.
Well, I would really appreciate that, because there is a tension here, isn't there, between ensuring that the information is getting where it's needed to help, but not potentially being accessed to cause detriment or to inappropriately breach the privacy. And that is a kind of interesting tension. And I would be really, some considered views from your organisation and those you talk with would be very helpful. Could I raise just one thing as you're doing that? I think there are good arguments for de-identified data to come, so as it can assist in research, assist in looking at trends. But one of the things I'm hearing from the work I do in relation to artificial intelligence is there is a greater and greater capacity for data crunching and for AI to actually identify de-identified data. And I don't know if you've had any experience of that or seen some of the trends in technology that are allowing for that re-identification of de-identified data. Has that come up in any of the work you've done?
Not so far, but certainly something for us to be conscious of. And I think especially for where we're using the data, that should be in the hands of certainly of professionals. It shouldn't be run through an AI, because we are dealing with an exceptionally human element here, that the numbers are helpful to inform us, but we're not trying to improve efficiencies here. We're trying to better people's lives. So I would, it's something certainly for us to consider in our travels about whether we're coming up against that, but it's not something I've seen so far.
And you know, one of the concerns has been raised with my office that the data may get fed into an AI at some point, and therefore they lose control of it. And perhaps that's something we should be checking with the government and the department, what their intentions are and what, if any, protections are in the bill.
I would agree, absolutely, and that those safeguards should be built into any internal policy and working policy that comes through from this. That this, I guess, mechanism is in effect, how it gets used is going to be exceptionally important. And AI is a serious question for many. So how are we using that safely and ethically? I think is an important question for government to be raising, for us as a community to be pressing as well.
Yeah. And Ms. Hennessy, I don't want to give you any more work, but I know your submission talks about how important reviews will be. And maybe if in your response you might think about perhaps if we should be highlighting these elements, making it obligatory for some of these elements to be covered in a review, how best we would do that. Thanks very much.
I'd agree. I spoke to earlier about the importance of having mandatory reporting, and that transparency is paramount, that even if it's bad data, we can learn from that. So I would, agree that anything that can be reported on should be reported on, even if it's something we don't end up using. That transparency at the moment is exceptionally important in building trust and paving our way forward into bigger and better programs.
Okay. Thank you very much for appearing today as a witness. The committee would appreciate any responses to any questions that we've taken on notice to be provided by 5 p.m. on Thursday, the 27th of August. Now, we're going to...
Not a worry at all. Thank you very much for having me.
Thanks, Shannon. Now, I'd like to welcome representatives from the Department of Defence, the Department of Veterans Affairs and the Defence and Veterans Service Commission. I'll give everyone a few seconds just to come up to the table and sort themselves out in that order. Now, the Senate, so everyone knows, has resolved that an officer of a department of the Commonwealth shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of a superior officer or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer having regard to the ground which it is claimed. If the committee determines to insist on an answer, a witness may request the answer be given in camera. Commonwealth officers appearing today also reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised, and a copy of that order is available from the Secretariat. I understand that information on parliamentary privilege and the protection of witnesses given evidence to Senate committees has been provided to you all. Now, for the Hansard record, for everyone at the table, could you please state your full names, the capacity in which you appear today, and for ease, I'm going to go from my left, so with you, Lisa, all the way to my right.
I'm Lisa Pulko. I'm the Deputy Commissioner at the Defence and Veterans Service Commission.
Ms Gillian Flinders, Assistant Secretary within Defence People Group.
Lieutenant General Natasha Fox, Chief of Personnel for the Australian Defence Force.
Brigadier Isaac Seidel, Deputy Surgeon General, Australian Defence Force.
Air Vice Marshal Lara Gunn, Head of Joint Support Services, Australian Defence Force.
Rear Admiral Letitia Van Stralen, Head of Military Personnel, Australian Defence Force.
Luke Brown, First Assistant Secretary of the Policy and Research Division in the Department of Veterans Affairs. Christina Raymond, General Counsel, Information Law, Department of Veterans Affairs.
Thank you for that. Now, I understand you might have a short opening statement, someone. Is it you, Lieutenant General Fox?
Yes, Chair, if I may. Thank you.
Yes, please.
Thank you for the opportunity to appear this evening on behalf of Defence. We have been listening to the other witnesses and thank them for their thoughtful submissions. The Royal Commission into Defence and Veteran Suicide highlighted the need for urgent and lasting change to improve the safety, wellbeing and support for our people. The recommendations of the Royal Commission final report emphasise that health, wellbeing and safety for ADF members, veterans and families must be central to Defence and DVA systems, practices and decision-making. It recommended improvements to information sharing, stronger support services and protections against family violence, as well as mandatory end of service for sexual violence and related offences. This bill gives effect to the key elements of the government's response to the final report through amendments to the Defence Act, the Military Rehabilitation Compensation Act and the Defence and Veterans Service Commissioner Act. The bill directly implements 15 recommendations of the Royal Commission and supports the further implementation of a further 20 recommendations for the Royal Commission, implementing or supporting 35 recommendations. This is structured across 5 schedules. The bill is focused on strengthening health and wellbeing and safety outcomes for Defence members, veterans and families. The schedules in particular, in Schedule 1 of the bill, addresses information sharing, Defence Health Services in Schedule 2 of the bill, family support in Schedule 3, service entry and exit arrangements in Schedule 4, and improved governance and accountability for Defence and Veterans Service Commission inquiries in Schedule 5 of the bill. It establishes clear and proportionate legislative authority for information sharing to support suicide prevention, early intervention, research, data analysis, evaluation, which is underpinned by strong privacy safeguards. It seeks to modernise the Defence Health Framework to align with contemporary clinical practice and national governance standards, improving the continuity of care and transition arrangements between Defence and the Department of Veterans Affairs. It enhances support and communication with our Defence families, particularly in situations involving family and domestic violence, and introduces fairer, more transparent end-of-service provisions. Together, these reforms will support a more integrated defence and veteran system that is better able to intervene earlier, use data more effectively and protect the health and wellbeing and safety of those who serve, who have served and their families. I'll leave it there, Chair.
Thanks, Lieutenant General. No other opening statements? Oh, hello. Last minute taker. Excellent.
I'd like to thank you for the opportunity to appear before you today. I would like to also offer my apologies from the Commissioner, Penny. She's in transit at the moment and unable to attend. The Defence and Veterans Service Commission commenced operation on the 29th of September 2025 as a new independent statutory oversight body. We've been tasked with providing evidence-based advice to government to improve suicide prevention and wellbeing outcomes for serving and ex-serving Australian Defence Force members, and to ensure accountability and transparency in the implementation of Royal Commission recommendations. Establishment of the DVSC was the key recommendation of the Royal Commission into Defence and Veterans Suicide. The bill before you proposes reforms which appear to support the Defence Portfolio's response to the Royal Commission recommendations across several themes, including wellbeing, health and safety outcomes for ADF members, veterans and their families. It is our role to assess the government's response to Royal Commission recommendations, including, where applicable, the effectiveness of legislative changes supporting implementation, such as those contained in this bill. This will occur through the following inquiries. Firstly, under Section 18 of the DVSC Act, the Commission will conduct 2 inquiries into the implementation of the government's response to the Royal Commission recommendations, due by 5 February 2027 and 2 December 2030. Noting the commencement provisions in this Act, the relevant measures in this bill will likely be considered in the second inquiry once they have been in operation for at least 18 months. Depending on the commencement dates, the measures relating to convictions for sexual offences may be considered in the independent inquiry into military sexual violence within the ADF, which is to commence in late 2026 and conclude by the end of 2027. There may be additional future inquiries where the implementation of some provisions in the bill may be considered. Meaningful implementation of the Royal Commission recommendations often requires more than legislative change alone. Our submission notes recommendations 68 and 74 in this regard, which appear to be addressed by measures in the bill designed to support information sharing. While the legislative amendments demonstrate work towards implementation of recommendation 74 in particular, the bill appears to establish an authorising framework to enable data and information sharing following the creation of further legislative instruments, meaning further work is required for the framework to be effective. We also consider that Defence's actions to uplift its data maturity will be critical to ensuring the information sharing reforms achieve their intent. The DVSC's current and future inquiries will examine whether the legislative reforms, together with those other associated implementation actions, achieve the intent of the Royal Commission's recommendations in supporting better outcomes for veterans. The bill also contains amendments to the newly commenced Defence and Veterans Service Commissioner Act. Firstly, to allow the Commissioner to provide a copy of a final inquiry report for an own motion inquiry to the Minister without triggering the tabling requirement in both Houses of Parliament, addressing an inadvertent change to how the legislation operated previously. This does not diminish the transparency of the work of the Commission, as we intend to publish all reports on our website, except where there are good reasons not to, such as dealing with sensitive or intelligence information. This amendment will ensure that the Commissioner can provide a copy of a report to the Minister and publish without the need for tabling. This is not unique. The Ombudsman also provides only certain reports to their Minister for tabling. This will provide the Commissioner with flexibility around the publication of reports and engagement with the Minister and is aligned with the intent of the Royal Commission. This amendment will not affect the tabling of the 2 reports on the Royal Commission recommendations required under the DVSC Act. The second clarifies that a person summoned to attend a hearing is required to attend day-to-day unless excused or released from attendance, and that failure to attend when not excused or released is an offence. I welcome the committee's questions.
Okay, now Senator Cox, and then I'll come to the Deputy Chair.
Thank you, Chair. Can I go to the DVSC first? Schedule 5 of the bill removes the requirement for reports of the DVSC to be tabled in Parliament. Was this change requested by the DVSC or proposed by the government?
This change was requested by the DVSC and it aligns with the legislation that operated previously and it also aligns with the intent of the Royal Commission.
Great, thank you. And can you explain for the committee why it's appropriate that reports of the DVSC would not be provided to the Parliament?
Sure. So the Commissioner can, under this amendment, the Commissioner can still choose to provide a copy of the report for tabling, or the Commissioner can choose to provide a copy of the report to the Minister for information and publish on the website separately. The current wording in the legislation requires any report given to the Minister to be tabled, which can delay tabling. And it can delay publication because we would wait for tabling before we made it public ourselves. It also aligns with paragraph 58 of the Royal Commission, where they said, we do not believe that every report should be addressed to Parliament. Some reports will be more suitably addressed elsewhere. For example, a report on a matter specific to the Army might sensibly be addressed to the Chief of Army, as well as being made public by the new entity without needing to be tabled in Parliament. So this allows us to send a report to the relevant agency and to publish without needing to go through the full tabling process.
Okay. My follow-up question is as the bill is currently drafted, that if the DVSC requests the Minister table a report in Parliament, is that required, or does the Minister retain discretion over that decision to table?
I believe that it is required to be tabled, but I'm just going to turn. Yes, I'm getting nods from behind. Yes.
Great. Thank you. That's it from me.
That's
Thank
right. Look, I'll go to Senator Schubert and I'll come to the Deputy Chair. Senator Schubert.
Thanks, Chair, and thanks to the Deputy. I really have a handful of questions about data. Who's best to walk me through what protections there are about the data that's shared in terms of privacy protections, data protections? Who's best to walk me through
Senator,
that?
I might start, and depending on where your questions go, I can share with the relevant areas. So in terms of data in defence, we share currently through consent-based mechanisms already data with DVA in relation to once a claim is submitted, DVA can access our health system to draw the relevant health information out of our compensation portal to support the claim. That's a consent-based system and only for a primary purpose. We also share information currently with DVA as well. They know who has joined the Australian Defence Force, they know who's transitioning already from the Australian Defence Force. And we do that through a Veterans Electronic Information Exchange Agreement. So we have data management agreements that determine how the data is to be used, how it is to be stored, who can access that data. We apply privacy principles, so the Privacy Act, but more fulsomely as well, we also apply the Protective Security Principles Framework in terms of security of our information in particular. Our people are trained in privacy. If they are accessing the HR system, for example, as administrators, they're required to undertake privacy training, and that is also built into curriculums in relation to our personnel capability officers and our clerks that are used to dealing with personnel information. For our clinicians and support staff in our health units, they are also required to undertake privacy training before they actually access health knowledge management system. So that's the data provisions and privacy that's applied across how the data is used and how we transfer it to DVA and ComSuper Corporation is through a data management agreement of which we all sign up to.
Right. But it's this, is it Part 6AB that's been proposed to be inserted into the Defence Act, which is creating the new proposed data sharing and creating new purposes for data sharing and permitting legislative instruments to be made?
That is enabling the provision of data in terms of being able to combine those data sources. In terms of, I'll get my team to confirm the relevant provision, which is happening now, but when we collect data and it's only for the primary purpose, we don't then use it for a secondary purpose. So what this will enable us is to fuse different data sources for secondary purpose to enable, and a practical example is that we are required to, through the Royal Commission, Recommendation 62, establish a brain injury or a brain injury program. That is new, the MBTI, a lot of science is coming through. So what we would be combining would be potentially medical, workplace health and safety information, what jobs they have been doing, so that we can actually affect that recommendation.
I suppose, I mean, this is concerns that's coming to me in volume about what this means, because the purposes in the legislation seem extremely broad. I think one is facilitating research, data analysis and evaluation, relating to, that kind of language is very broad, relating to health or safety. And the other one is to support wellbeing, health or safety outcomes. Now, I know there are some limitations about it being used for an individual case, but the breadth of it and the fact that all the protections that are proposed are going to find themselves in an as yet undisclosed legislative instrument is causing anxiety. Is there a draft legislative instrument you can share? There must be some working on this, or instruments that you can share.
We don't have a draft. Are you talking in reference to the ministerial guidelines there, Senator?
Yes, my understanding is the circumstances within which that information can be used, will be limited, will be expressed via a legislative instrument?
I'll talk to two parts, if I may, and then I might ask if my DVA colleagues want to add to that. Firstly, I'll talk about research. For research to be conducted, certainly on serving people or using serving people's data, there has to be an approved research program, and that research program still is required to have ethics approval. That still puts safeguards around data. So that's one aspect. The ministerial guidelines themselves will be managed. The sensitivities around data, the ministerial...
I think there are two separate things.
Yep.
One is the instrument setting out how, what, where and why.
Yes.
And what classes of data and how it can be used. That's my understanding. It's not my legislation though. And the other one is a guideline that puts some kind of information handling limitations on it and constraints on it. They seem to be, as I said, that's why I'm asking these questions.
So it's de-identified data for the, I would say, population health benefit. That would be used. As you said, it's not individual data as currently occurs through consent-based mechanisms. And in terms of developing the ministerial guidelines, they'll be developed following passage of the legislation. The Minister must seek advice from the Australian Information Commissioner and have regard to that advice, and that's in the bill. If the Minister is not the Minister for Veterans Affairs, the guidelines must be made jointly with the Veterans Affairs Minister, and the legislative instruments will be publicly available and subject to the usual public scrutiny or parliamentary scrutiny arrangements.
Lieutenant General, I don't mean to cut you off.
No, that's okay.
But I suppose I'm interested to know what the difference between the two instruments are, the instrument and the guidelines, what the instrument's aimed at, what the guidelines are aimed at. But my first question is, what's the instrument aimed at? What are you intending to aim it at? And when there are provisions in the bill like the impact on privacy to any individual member needs to be proportionate, these are the kinds of phrases that are just putting warning bells out. And it's not very well explained in the explanatory memorandum. I don't know. I have no idea what it's aimed at. As I said, I can see systemic reasons why you want to have information sharing.
Yeah.
I can see why you don't want to have veterans and or serving members repeat traumatic information. There are good reasons to do this, but I can't see what the protections are. So perhaps we might break it down into bits. Will the instruments be disallowable?
So the guidelines...
I think the answer is yes.
The guidelines are subject to parliamentary scrutiny.
Well...
And the guidelines...
So is both the instrument that specifies as the use and disclosure, that's one, that's going to be disallowable, and will the guidelines also be disallowable?
The guidelines...
I'm seeing nods
the guidelines,
from General Counsel. Is this right?
Senator, I might defer to colleagues at the Department of Defence, noting that the amendments are to the Defence Act. My understanding, however, is that they are a legislative instrument and the bill does not provide for non-disallowance, and therefore the provisions of the Legislation Act apply and provide that they are subject to parliamentary disallowance.
Thanks, Ms Raymond. What I suppose is, I think this needs to be articulated in some detail, what it's intended to cover with the instrument, what it's intended to cover with the guidelines, and what kind of protections are in. So if we're not in a position to do it now, then I'd be really appreciated coming on notice, and I might invite you to give it on notice so as we can have a...
I can give you some framing now, which is what we're working through. The guidelines will likely include matters such as the consent requirements, the circumstances where at de-identified data without consent may be justified, the de-identification requirements, the privacy protections, the security requirements, the governance and accountability mechanisms, and the conditions on information use and disclosure. The guidelines will likely include, as I said, we're developing them, transparency and accountability measures such as publication of information about approved proposals, annual reporting requirements by Defence and DVA on operation of the framework, and a review of the guidelines within 24 months of commencement. The Information Commissioner is key on that. The instrument is the ministerial guidelines. There's one, not two.
So there's a single instrument.
There's a single instrument, and that is the ministerial guidelines.
And the instrument will set out the collection, use and disclosure of the information?
That's correct.
What its purposes are, and we'll also put whatever the guidelines are about how the information, it's intended to be a single instrument. Is that right?
That's correct.
Well, I invite you on notice to indicate what it is, what information you're intending to use, what purpose you're intending to use it, where you're intending to share it, as best you know now, because
we'll take that on notice then, Senator.
I suppose could I also invite you to respond to concerns that have been raised with my office about the ability of AI to re-identify de-identified data? Has that been considered?
I have not considered it in terms of this, but we can consider it in terms of how we construct the ministerial guidelines.
And what, if any, protections are intended to prevent serving personnel's data or veterans' data being fed into an AI model, which we could never get that out again? Are there prohibitions on AI? What restrictions are proposed before data is fed into AI? Is that, you're able to articulate that now?
That sharing of data at the moment that we have now with Defence DVA ComSuper Corporation is governed by that data management agreement. The reason the preference is for the instrument or the ministerial guidelines is to account for exactly the circumstances you're raising. Because technology is moving so fast, we can adjust that guideline more fulsomely and quicker than we can do a change to a Defence Act. So that's.
But you say some of it's covered currently by an agreement?
We have an agreement.
That's a non-legislative item.
That's correct.
Can you provide a copy of that agreement to the committee?
I'll take that on notice, Senator.
All right, thanks.
Senator, can I just to circle back slightly to one of your earlier questions about giving you and the committee and the community a sense of what will be in the guidelines. This framework integrates with the Privacy Act framework that already exists, and similar provisions exist under the Privacy Act under Section 95, which provides for similar guidelines to be made under that Act. So just in terms of giving you some assistance, those are the sorts of guidelines that are envisaged.
What I would say in response to that is the current Privacy Act was drafted in 1988 and it's fit for 1988. And last time I checked, it's about almost, half a century beyond, and it's clearly on questions like AI and online data sharing, re-identification, it's not fit for purpose, and rather than keep repeating past mistakes, are you looking forward?
Thanks, Senator. I was just in response to your concern around
I appreciate
visibility.
it, yeah, thanks.
All right. Senator Collins, you got some questions for us? Thank you.
I might just extend on Senator Shoebridge's line of question. We had a witness before, Mrs Hennessy, that recommended that plain English summaries regarding which protections apply, privacy protections and so forth, be provided to veterans concerned. So is that something that the department is considering?
Yes, Senator. We're very happy to provide fact sheets that explain how data is used. Indeed, at the moment when we are, and I can give you a short vignette, we are working with Department of Veterans Affairs on the pleader data set. We did a very big communications program in Defence about consent-based. What does it mean? What's the program? What's the data used for? To enable people to make an informed choice about whether they wanted their data to be used. So we're very... It's part of our normal practice, including in research for people who may want to volunteer for research. It's an individual choice for volunteering in research, and they are given fact sheets about that participation as well. The current sharing that we have, it's expressed in about Defence and DVA and through Life Support Continuum, and people are consenting to their information being shared with DVA now on that basis. So we are very happy to continue to provide education and fact sheets, particularly about the information sharing and the ministerial guidelines, if that assists people to understand what their data or information is being used for.
We were hearing before about the discretionary tabling. It's not automatic. Does anybody have any, I guess, explanation as to why it's discretionary and not automatic?
Sure. The legislation that we started out with had it as a discretionary tabling. When the new bill was drafted, there was an oversight and wasn't picked up until afterwards. We are looking to move back to the discretionary tabling. If the Commission provides a report to the Minister, at that point it is required under current legislation. If any report is provided to the Minister, it is required to be tabled. That means that there's very little in terms of light and shade for us around what sort of reports we would want tabled versus requirements for us to just deal with the particular agency. We would expect that...
Sorry, can you explain the requirements to deal with is that a report, are you saying?
Sorry, so any report that is done currently would need to be tabled if we provide it to the Minister. What we would like to have is the option to provide a copy of a report to the Minister that isn't tabled. That would only apply to own motion reports. The reports that are required under the DVSC Act, which are the two reports, would be required to be tabled anyway, as would any report that is requested specifically by the Minister.
So why do you not want to table the own motion reports?
There's no particular reason that we don't want to table them. There will be some reports that we complete that won't be of a significance that we would think would require tabling. And
could you give us an example?
We haven't completed reports as yet, so I don't have a live example that I can provide for you. But this is a model that is used under the Ombudsman's arrangements. The Ombudsman's arrangements only require tabling after a certain number of thresholds are met. And where the Ombudsman provides the report to the Minister and requests tabling. We're looking at a model which aligns with an existing model with the Ombudsman. We're not intending through this change to diminish transparency. The Commission doesn't have powers to compel change. Our leverage is really through reporting and through public reporting. So it is our intent to make our reports public, whether through tabling or through our own website. Unless there is a very good reason, and that would be for intelligence purposes or highly personal information included in a report, we would be publishing everything on our website anyway.
Okay. Personal information can always be redacted. Will there, because there's no mention in here about the thresholds that would be similar, so will they be exactly, will you be implementing a process of thresholds or, and will they be exactly the same? I mean, what can we expect from that?
So the thresholds that are used by the Ombudsman are not relevant to the work of the Commission. They require an investigation to be completed, report being provided to an agency that isn't then acted upon. So those particular thresholds the Ombudsman's using in terms of an investigation, we're not doing investigations, we're doing an inquiry, so there's a different approach. For us, anything that is a legislated requirement for us to complete will go to the Minister and will be tabled. Anything that is an own motion inquiry would then be at the Commissioner's discretion as to whether that would be provided to the Minister for tabling or would be published on our website. If it is provided for tabling, it automatically requires a requirement from government. A requirement for a government response. Whereas if we liaise directly with an agency, we can have an agency response where it is not necessary for a full government response.
Okay. Can you just, I think I've already asked this, but just some examples of what an own motion inquiry would look like. What's the two ends of the scale here where you think something is insignificant, something is significant enough that we should know about it?
So an own motion inquiry could be on any theme that we consider is necessary to, the Commissioner considers is necessary to look at. that wouldn't necessarily be a specific recommendation from the Royal Commission. Royal Commission recommendations are required to be looked at under our legislation and will be reported to Parliament. If the Commissioner had, and we do get often correspondence from different people around different issues that they're seeing, and the Commissioner saw a theme around a particular issue, which may be something along the lines of access to information. It could be something that is connected to an existing recommendation but not purely the recommendation that exists. It may be that we're seeing coroner's reports coming through that don't align exactly to existing recommendations. The Commissioner could choose to launch an own motion inquiry. There is a lot of information that comes through to us from a lot of different people in the community, as well as research that comes through. And there may be something to do with brain injury. There may be something to do with access to information, which is one that we're looking at currently. There may be something in relation to access to legal aid. There may be there is quite a range of issues that are brought to us that don't align very well with existing recommendations, but we'd still like to be able to look at them because we still think that there are very practical ways of making lives better for our serving and ex-serving members.
They all sound like, really important inquiries to be done, and the sorts of information that would be helpful to all sides of government to be seen as well. So under what circumstances would any of that sort of thematic inquiry not be deemed important enough to be tabled?
There may be something very niche that is looked at. There may be many broad things that are looked at. It's not necessarily that we wouldn't want Parliament to see it. We would be publishing it on our website regardless. It may be that we want to move quickly and tabling can take some time. It may be that the issue itself is very confined to the IGADF or to Army specifically or to the ABS specifically, in which case the government response isn't necessarily required when we can get a response directly from that agency, which would then also be published on our website. The agency response, as well as our report, would go on our website.
Is there any appetite at all for perhaps, let's say you do 5 insignificant enough inquiries to not be, or niche inquiries, that by the end of the year you table a report of all those smaller niche inquiries to... I just feel like, these things are important enough for you to do an own motion inquiry that, we would love to be able to see as well. That it can... You guys all see it. We have huge information overload, so we're going to miss stuff like that. But if it comes through the Parliament, then everybody can enjoy and share in that important inquiry. So I'll just leave that with you, I guess. On the 12-month limit for the safe separation payments, we've heard a lot of evidence today that that's not quite long enough because there's often reasons why, there's barriers to, I guess, being able to get those payments. We heard previously from Dr. Lax at Legacy Australia that often they won't provide services or support until well after, you through that initial shock and grieving process. So can somebody please explain why there's a 12-month limit and perhaps not 24 months?
So thank you for that question, Senator. So we of course recognise that in defence we do have a responsibility to both prevent and mitigate the impact of family domestic violence on our personnel. The view that we look through is it is about the safety of the individuals first and foremost. So the 12-month period was considered because the proposed amendments in this bill are intended to enable that safety and that transitional support that directly assists that safe separation. We assess that 12 months period provides time for former partners noting that they will continue to have access to support services while they are still recognised as a partner. So the clock for the 12 months commences when they are no longer recognised as a partner. So that 12-month period, we assess, does provide time for those partners to establish access to alternate support arrangements and services, because the 12-month period is to assist the partner from leaving that relationship. We also recognise that other specialist Commonwealth, state and territory agencies and service providers that are specialists are better placed to then provide that medium to longer term social and welfare assistance.
What's the trigger that you said before that you wait until they're no longer recognised as a partner? What's the definition of that?
So the members or the family of members are recognised when the serving member themselves submits an application or a form to no longer recognise that relationship, or no longer to have defence recognise that relationship. So it is initiated by the serving member.
Okay, so if I understand this as a safe separation payment, but up until that point, let's say you've got a family fleeing domestic violence, and that person committing the violence, coercive control, doesn't want to admit that the relationship is over, there's still supports for them up until that time. So let's say that goes on for 5 years, 10 years, that point at which, they could even still be divorced legally, and you still have to wait for that person to say that they are separated?
So those supports remain in place for the family members right now under our current legislation, up until the point in time that that individual is no longer recognised as being a member of the serving member, so a part of the family or a dependent on the serving member in that regard.
Okay. What sort of supports do they get during that period? So
right now, if you're a family of a serving member, for family and domestic violence cases in particular, and we have a 1800 all-hours helpline that is available to family members. They are not specialist family and domestic violence providers, but they do provide advice and guidance in connection to those specialist external Commonwealth, state and territory providers, and also continue to provide some limited triage case management. Where there is an immediate risk of harm, there is, of course, the normal legislative reporting obligations. We also currently have a safe housing scheme that enables the 1800 helpline social workers and team to, when the family member requests immediate access to housing, that we are able to provide that as an immediate support team member while connecting them to those specialist family and domestic violence service providers.
Okay, and once they get connected to those service providers, do they get any financial assistance, direct financial assistance?
From Defence? Yes. Not specifically for that purpose, no.
So in that sense, it would be difficult for them to be able to, if you don't have a working spouse, it would be difficult to actually remove themselves from that situation and then eventually become formal partner.
I might correct myself there, Senator. I think I misunderstood your question. While they remain recognised by Defence as a family member, they will still have access to ongoing support, which can include travel and housing services within Defence.
Okay, so they'd be able to have a separate house.
The existing set of benefits, if that relationship does break down, and obviously if they are looking to separate safely from that relationship, there is a point where they will no longer be recognised by the member as being in that relationship. That's what this bill is looking to do, is to bridge that gap, to enable that continuity of access to benefits like travel, like housing, so that there is not immediate cut-off as occurs at the moment.
Okay, but you still have to wait for let's say if we're talking about domestic violence, a perpetrator to say yes and they're leaving and yes, they need a safe payment.
Senator, I might say, so...
I'm just trying to understand it.
Yeah, so currently if we have a family and domestic violence circumstance, family members can call the hotline, the helpline I should say, and get immediate support in the safe housing construct. That's the family member can arrange that through the helpline. And So that remains. Once the family, if the family has declared it's broken down, then from the date of that breakdown, it's an additional 12 months of access to housing and travel in some circumstances, as my colleagues has said.
Okay, thank you. In relation to information sharing and advocate access to records, now submissions to this inquiry highlighted the bill provides no formal pathway for accredited advocates to receive transferred health information, even with a family's consent. Is that? So why is Defence routing these sensitive records through grieving family members personally rather than allowing them to authorise professional advocacy support?
Senator, I will, in terms of for the provision of health records to a grieving family, we can and do provide and work with advocates, but I will allow my colleague to answer that.
Senator, thank you for the question. To this point, I will acknowledge that there have been some challenges historically, and we thank Legacy for their submission in regards to this. This bill does provide a provision for a senior decision maker in Defence to release the health records of a deceased member on compassionate grounds, and that takes away the previous ambiguity which required those grieving families to obtain a certificate of grant of probate or letters of administration. That will no longer be required under this bill.
Okay. On Surgeon General qualifications, the Australian Medical Association notes that in most NATO militaries, the Surgeon General must be a medical practitioner. So why does this bill not explicitly require the Surgeon General ADF to be a registered medical practitioner with specialist qualifications to ensure clinical authority? I'm not entirely sure who would be qualified to...
I'll take that. Yeah. I'm not a Surgeon General. I am accountable and responsible for the Surgeon General in administering her responsibilities at this point. And by practice, the Surgeon General is an accredited medical professional, a doctor, and Defence has no desire to change that. I'll let my colleague, the Deputy Surgeon General, see if he wants to add anything further.
Senator, I might declare an interest as a member of the Australian Medical Association.
Sure. Thank you.
I'd also note that the Royal Australasian College of Medical Administrators made a similar submission, and I'll declare my interest as a member of that organisation as well.
You're a busy man.
By convention, the Surgeon General of the Australian Defence Force has always been a doctor. Yep. The decisions about selection for senior appointments are made by the Chief of Defence. Clearly, the requirements in the bill for clinical governance, the accountabilities of the Surgeon General for health policy, for leadership of the health system would indicate a health professional needs to be in that role. It would be inconceivable to appoint someone who is not appropriately qualified to provide the leadership in that regard.
Okay, thank you. Just two more questions, Chair. We heard before from Legacy Australia about the term family member and that it's undefined in the bill. How can Defence ensure consistency and prevent uncertainty for adult children or siblings who might need to request information after a veteran's death?
Senator, I'll take that one as well. So family members are indicated in... the immediate family members, I should say, are indicated in our current health, human resource management system. So we are aware of children, spouses, and family may declare other members to be recognised, and we do recognise other people in our system as well. So we do know to a certain extent, but we also know that family dynamics in our contemporary time are very different, and there are many makes and types of families. So we will often work with a member themselves around their wishes on information. And at present, we also have our members make wills, particularly if they are deploying, and their wishes are expressed in wills as well. So we have some other mechanisms. We do work with the families themselves. The member themselves declares their family. So that's how we know who our family members are.
Okay. All right. Thank you. Just on coercive control, so we heard from Legacy before that Dr. Lax recommends that unacceptable behaviour standards should be defined broadly enough to capture coercive control, not just physical violence. So how does the bill's supporting guidelines address rank as a coercive lever in domestic and workplace relationships, but also if you could just reflect, I guess, on that matter of coercive control under this bill?
So, Senator, I'll take the first part and then I'll defer to my colleagues. In terms of relationships in defence, we have many different rank relationships in terms of informal relations, so married, informal relationships. Where you're in an intimate relationship, that relationship is required to be declared, and in that declaring of a relationship, that's not for that's so that we can manage people and not have them in the same chain of command, and remove those circumstances where they've got a chain of command relationship. Mm-hmm. So, and that means they're reporting to different people, and so if they need support for certain matters, they can go through a chain of command if they need to. They can go to a helpline if they need to, or they can make an anonymous complaint now. We have an anonymous complaints framework where they can make a complaint about an individual as well. So the mechanism that we manage intimate relationships to avoid conflict is through declaring them and managing them in separate chains at the moment. I'll go to the coercive control part to my colleagues.
Yeah, thanks very much. So I'll add to that. So in terms of coercive control and all of the various elements of family and domestic violence, that is already defined within our policy. So noting that family and domestic violence as a category and all of the components that are part of that continues to evolve with time. So coercive control as a particular behaviour that is part of that subset of family and domestic violence is already defined in policy, and the definitions and the categories that we use align with those in the National Plan to End Gender-Based Violence, so that we continue to evolve and update our policies, our definitions, our understanding of these behaviours, and that they are part of that broader umbrella of family, domestic and sexual violence in that regard. I understand that Dr. Lax was specifically talking about coercive control being called out relating to the part of this bill that relates to automatic end of service. And the bill does cover that. It covers imprisonment for any offence that has resulted in a custodial sentence, including suspended sentences, that will result in that automatic termination of service.
Okay, thank you. Just one final very quick question for me that I remember seeing a couple of weeks ago there is a helpline. Just when you're talking about helplines, there's a helpline. I think it's 1-800 I'm sick. Is that right?
Yes, Senator.
Is that just for physical unwellness, or is it for mental health as well?
It can be for both, Senator. I can defer to my colleague who is part of the Joint Health Command that's responsible for I am sick. Okay. But in general terms, if I'm unwell on a weekend and I want advice, I can ring up and get triaged through that helpline, and there are health professionals on that back end, and then they can refer me to different parts of the system, but I'll refer.
Senator, the medical advice triage and referral service is available to all serving Australian Defence Force members. Indeed, family members on behalf of serving members have used that line to access support. It is staffed 24 hours a day by registered nurses who have access to protocols that can support those members and then refer on as necessary and based on the urgency that they assess, including a warm handover to jurisdictional ambulance services if they assess that the situation is an emergency. Each morning, the health centres that support Australian Defence Force members receive a report detailing all of the calls that have been made so that they can make follow-up calls if necessary. But as a general rule, it is a very well accepted program. I've used it myself. Indeed, they can also provide sick leave. We used that during COVID-19 where members could explain their symptoms, obtain advice and then be given a sick leave certificate through that service.
It sounds like an excellent service. And I guess my question would be, how much do you get, self-initiated people calling up that feel like, hey, maybe I am, I'm mental ill health. And the reason I ask that, and no disrespect by this at all, but I guess the actual, the acronym, whatever it is, from the going from the numbers of I'm sick, does that put people off, if they're trying to admit to themselves that, hey, I might have a problem trying to call this number, like, is there another number that they can call if they want that initial sort of, I don't want to tell anybody, but I think I might be unwell?
Senator, we, in all forms of correspondence that we put out, we put a large number of contact details out for people to make their choice, and we are working to make sure the consistency in the presentation of those numbers are the same. So that if you are in distress and you've looked at it once or twice before for different reasons, there are numbers on there. That includes Open Arms, it includes Lifeline numbers, it includes the Defence Member and Family Support Helpline that also work and can triage into Open Arms, as they currently do as well, and the 1800 all-hour support line. So we do provide people choice, and we recognise that if you're in distress, there's a degree of familiarity so that you can actually pick a number and get to the right area. There is no, what we're trying to make sure, there is no wrong entry to get support when you need it.
Yeah, excellent. All right, thank you very much. Thank you for your time tonight. Appreciate it.
Thanks, Deputy Chair. Look, I've got a few questions before we conclude tonight. With respect to the Royal Commission, it recommended that it be mandatory discharge for ADF personnel convicted of sexual offences, and as drafted, as I understand in the bill would not be required, require convicted personnel being discharged unless they were sentenced to a period of imprisonment. Why does the bill not require any mandatory discharge of sexual offenders as recommended by the Royal Commission?
Senator, there are some technical legal reasons, and I'll get my colleague to explain that at the moment. This bill is about the mandatory removal from service if you are in prison, so you've already been convicted through a court system for a conviction, and it's any conviction for imprisonment that you are mandatorily removed from the Australian Defence Force because you can no longer actually serve in that regard. However, in terms of we have other regulations that have made it mandatory to consider the status of an individual service, and I'll defer to my colleagues now on that.
Thanks, ma'am. Thanks, Senator. As the General's indicated, certainly there's the automatic provision if a member is imprisoned. That indicates that the member can no longer provide unrestricted service. We considered whether there needed to be procedural fairness, but given that they'd been through an Australian court system, whether that's military or civilian, they have been given the opportunity to actually respond to those allegations, and the court has determined beyond reasonable doubt that they have committed certain offences. So in that basis, as soon as they're sentenced, then their service is terminated without procedural fairness. Prior to this bill, we'd have to initiate a notice to show cause for an involuntary separation, issue it to the member that is incarcerated, and enable them to provide a response before a decision was made. So this gives effect to recommendation 22 of the Royal Commission's report, and provides that automatic and legislated effect to have a mandatory outcome.
So if the sentence is suspended?
It's the same case.
Okay, so as long as there is a sentence of some form?
Correct, Senator. It's on the basis that they can't provide unrestricted service. So even in the case of a suspended sentence, it's indicated that they've committed a serious offence and that they're unable to provide that unrestricted service.
So there's obviously instances where someone can be convicted, but no sentence might be attached. What happens in that instance?
If they're not imprisoned, then we will certainly have, under the regulations as well, 24(1) Charlie, 24(1) Delta, we do give consideration then to the outcomes. So in that case, there's a mandatory notice to show cause for an involuntary separation issued to the member, and then it goes to the appropriate delegate to consider what that outcome is. Effectively, they're looking at whether the individual is a fit and proper person to continue to serve in the Defence Force.
So why does Section 22A of the bill apply only to serious sexual offence rather than all sexual offences?
Sorry, this is in relation to 22 Alpha, was it? The
Yes.
only fit and proper persons. So convicted. So under that section, those convicted of the serious violent and sexual offences that have been sentenced to imprisonment obviously won't be fit and proper persons. Those individuals that have been convicted of offences overseas or other offences overseas or under Australian law, it then gives the delegates the opportunity to actually consider whether they are a fit and proper person to serve in the ADF. The Chief of Defence Force and the delegates under the Chief of Defence Force also have the ability then to consider that fit and proper person test. Ultimately, we want a Defence Force that is a trusted workforce. They are competent, they are reliable, they're honest, trustworthy, of good character, and can meet the inherent requirements of the service.
But are you saying that you're not just looking at serious offences, but are you looking at all offences?
Correct. For any entry into the Defence Force, we look at the fit and proper person test. So if an individual has been convicted of potentially like a fraud offence or something like that, we would consider that goes to their character and to their...
But with respect to sexual offences, the bill, as I read it, makes it pointed to serious sexual offences, not just all sexual offences.
Serious violent offences or sexual offences. So
are you satisfied that that would capture all sexual offences?
Yes.
Not just a narrow definition of serious?
Correct.
With the concerns that the committee has heard so far, particularly around the Schedule 4 being exercised as low as the EL1 level, are similar powers within the ADF or Defence currently being exercised at this level?
There's a number of delegations from the Chief of Defence Force across a variety of ranks, and that's a determination by the Chief of Defence Force based on what the decision-making might be in relation to. And certainly those delegations, whilst the legislation might say we can have a certain rank, the Chief of Defence Force will actually issue a set of delegations, an instrument of delegation to individuals or to individual ranks or groups.
But do you know if anyone has been exercised those powers at those levels?
Certainly, if I look at Section 22A, the fit and proper person to serve in the Australian Defence Force, I have military recruiters that are various levels, various rank levels. If I look at then end of service for fit and proper person tests as well, that's a centralised decision making within the military personnel division, and we have personnel from we refer to Lieutenant Commanders or 04 level and above that can make those decisions. So it really, yes, is the answer. We have applied those delegations to those various ranks.
There are personnel regulations. The Royal Commission itself said under 24(1) Delta in our current personnel regulations, the service chiefs are the delegates for removal of personnel for sexual offences. So that is actually quite high in the personnel regulation. Our delegates are trained and have refresher training every 6 months, and so they have to be able to be trained, have the suitable experience and qualification, and in order to fulfil the duties of a delegate in decision making. But in relation to the only fit and proper person to serve in the Australian Defence Force, the delegations around that are managed, as my colleagues said, by CDF on instrument only one level down, or to select a particular rank for the exercising of that delegation, but only if they are trained.
Well, I was about to ask, so what training or frameworks will be put in place to guide the decision makers in exercising these powers?
Sorry. So there's mandatory delegation training at the beginning of each year, and then we do a refresher training midway through the year, and that provides direction and guidance on the legislative framework. It provides information on procedural fairness. It provides guidance from the service chiefs as well to make sure that delegates understand what is in the mind of the service chiefs as well. So it covers a number of areas to ensure that delegates are actually able to make those decisions. We also then provide support for the delegates on a regular basis because they are dealing with sometimes difficult situations and complex situations. So we're engaged in our workplace in conversations to ensure that people are looking after their wellbeing as well as understanding the types of decisions that they're making.
Okay. Well, thank you very much. On that note, if there's anything that we've asked you to provide on notice, if you could provide that by 5 p.m. on Thursday, the 27th of August. That does conclude this hearing today, and I want to thank everyone who has appeared and thank Hansard Broadcasting and the Secretariat. The committee now stands adjourned. Thank you.